Hey everyone, it's Rohan here and hope all of you are doing great. So after some time, there are again some events happening in the Ripple versus XRP case. Here, the James K. Phelan, the defense attorney from the Ripple side, has just published these documents, and these legal documents are all about SEC's objection to certain portion of the documents being made public. And if we are meeting for the first time, very welcome to this channel. Here you will find me every day discussing the latest in cryptocurrency market. So do hit the subscribe button. So the SEC has been trying to keep the Hinman speech related documents and emails private, but they have failed to do that so far. People have been talking about these documents quite a lot lately, and the SEC does not want them to be made public. Now, to give you the context behind this situation and the case, the regulator is accusing, that is the SEC is accusing Ripple of selling unregistered securities in the form of XRP tokens, raising over $1.3 billion. And over the last few weeks, this Hinman speech document gained a lot of media attention in this case. These Hinman speech documents are about the speech made by William Hinman, who was a former director of the SEC's finance division in June 2018, in which he allegedly denied that Ether, the native token of Ethereum blockchain, is a security. So Ripple could get access to these Hinman documents, which are internal SEC emails back in October 2022, only after a court ruling. The SEC had sought to block release of the documents since Ripple initially asked for them a year and a half back. First on the grounds of deliberative process privilege and then on the basis of attorney-client privilege. But the judge hearing the case, Annalisa Torres of the US District Court for the Southern District of New York, last month said that SEC had to turn over the material as it met the test for relevancy under the extremely broad concept of relevance used to resolve discovery motions. And now about this yesterday's tweet from the defense attorney James K. Phelan. The Ripple defendants have filed their response to the opposition to SEC's motion to seal certain documents filed in connection with parties' cross motions for summary judgment. So SEC is trying to redact some portions of the documents, and Ripple is objecting to that. And just to be clear, a redact motion is a request to remove specific information from a case before it is made public. This is usually done to protect sensitive or confidential information or to comply with legal requirements. Alright, here is the document. Defendants Ripple Labs right to oppose SEC's later motion to seal certain documents filed in connection with the parties' cross motions for summary judgment. As the court has recognized now that this case has proceeded to the summary judgment stage, the presumption of public access to judicial document is at its strongest. The SEC has nonetheless persisted in seeking to shield from public view the names and identifying information of witnesses whose testimony the SEC intends to rely upon to prove its case without identifying any compelling interest suggesting that secrecy is necessary. Further, in seeking to seal documents relating to former SEC Director of Corporation Finance William Hinman's June 2018 speech, that is the Hinman speech documents, the SEC seeks to keep from public documents of intense public interest upon which the court ordered discovery and which defendants have used to support parts of their summary judgment motion. Whether or not the court ultimately determines those documents are relevant is besides the point. They are part of the summary judgment record and there is no compelling basis to keep them sealed. The SEC's motion should be denied. All of the documents the SEC seeks to seal were submitted for the court's consideration in connection with motions for summary judgment and are accordingly judicial documents entitled to a strong presumption of access. The SEC has not met its heavy burden to support its request to seal witness names and affiliations. The SEC's request for an order sealing the names and identifying information of the SEC's own fact and expert witnesses at the summary judgment stage should be denied, while this court granted the SEC's request to seal the names of its experts at the non-dispositive Daubert motion stage. In doing so, the court explicitly recognized that the SEC's renewed request at the summary judgment phase must be evaluated under a different and more demanding standard because the presumption of public access is now at its strongest. The SEC's Category 1 request asks the court to seal the names and other identifying information of two sets of witnesses. 1. All of the SEC's disclosed expert witnesses, and 2. A number of SEC's proffered fact witnesses, each of whom voluntarily submitted a declaration in connection with the SEC's motion for summary judgment and whom the SEC broadly and inaccurately lumps together as investor declarants. The SEC's request to seal the identities and affiliations of fact and expert witnesses whose testimony is demonstrably relevant to the court's decision-making at summary judgment is not supported by the kind of specific, compelling facts necessary to justify such an extraordinary sealing request and should be denied. First, the SEC repeats its prior request to redact the names and identifying information of SEC experts prophylactically out of a concern for their safety. Yet, the SEC fails to differentiate between the circumstances of each of the different SEC experts. The identities of 3 of the SEC's experts are already publicly known, and a brief period of criticism directed towards one of those experts does not justify blanket sealing of these already public names. Beyond that, the SEC claims in support of sealing that the identities of its experts have no relevance to the court's decision on summary judgment. But of course, the identities and experience of expert witnesses are key to the weight that the court may decide to assign to their opinions. Under the more demanding scrutiny required at the summary judgment stage, the SEC's generalized arguments do not hold water. Now look at this. I found this to be pretty important. That an expert's opinion or qualification may be subject to public criticism should not be a sufficient basis to seal their identity in connection with summary judgment motions, and the SEC has made no showing of any real physical danger to these experts. The SEC's experts are paid professionals whose testimony the SEC has offered in a public enforcement action against defendants with substantial potential consequences for an entire industry. To review the strong presumption of public access, the SEC must offer more than an unsupported blanket assertion that the redaction of all information about the identities of all of its proffered experts is narrowly tailored and appropriate. Second, the SEC seeks to redact the identities of so-called investor declarants. Each of these witnesses affirmatively drafted and submitted testimony for this court to consider when resolving the SEC motion for summary judgment on its merits. That renders them judicial documents subject to the highest presumption of public access. The SEC's only support for its extraordinary request to keep the identities of these witnesses secret is a district court decision approving the reduction of third-party names mentioned in exhibits to a motion for a preliminary injunction. So they are talking about this case, SEC versus Telegram Group in 2020. So that decision in no way supports sealing the names of witnesses who submitted declarations in support of a summary judgment motion. Indeed, in reaching its holding, the Telegram court specifically noted that these proposed redactions were for passive non-party investors who might be embarrassed to have their historical conduct associated with an enforcement action, which is unlike the declarants here who have chosen to offer new sworn testimony in support of the SEC's motion and play an active role in this litigation at the summary judgment stage. Hence, the SEC's generic conclusory assertion that these redactions are appropriate to protect the identities of these witnesses does not provide a specific or particularized basis to overcome the strong presumption of public access to judicial materials at this stage. And the next point or the next section is about the Hinman speech documents or judicial documents relevant to the court's consideration of the parties' summary judgment motions, and the SEC has not overcome the strong presumption of public access. At the outset, the SEC's suggestion that Hinman speech documents are not judicial documents or carry a lesser presumption of public access is incorrect. Defendants relied on these documents in their briefs in support of their summary judgment arguments, meaning that they may have the tendency to influence the court's decision on the summary judgment motions. While the court has previously suggested the Hinman speech documents may have only narrow admissibility at trial, that decision was based on an incomplete record at the time. Defendants had not yet reviewed the documents to develop or set forth their arguments about their potential relevance to the SEC's claim and their defenses. The court now has the benefit of defendants' views regarding the considerable relevance of statements contained within the Hinman speech documents to review the SEC's claim that defendants' sales of XRP constitute investment contracts under the Howey test, support defendants' fair notice defense, and review the individual defendants' alleged recklessness. But even if the court ultimately determines that these documents are not admissible or does not rely on these documents in ruling on the parties' summary judgment motions, the Second Circuit has made clear that documents do not receive different weights of presumption based on the extent to which they were relied upon in resolving a motion. Thus, regardless of the court's ultimate ruling, the Hinman speech documents are judicial documents that should not remain under seal absent the most compelling reasons. In addition, there is no question that there is a significant public interest in the content of these documents, which weighs heavily against sealing. The SEC also argues that the court should keep the Hinman speech documents sealed so that the SEC can, in the future, argue that the documents are privileged, but the authority it cites does not support that relief. The Lugos court nowhere suggested that the SEC cites no authority suggesting that documents should remain sealed despite a ruling that the privilege did not apply. It is therefore unsupporting that courts in this district have historically denied requests to seal documents after concluding that they were not privileged, even before the parties had an opportunity to appeal those privilege rulings or to assert the privilege in other litigation. Alright, so that was Ripple's defense against SEC's request to redact the Hinman speech document, and in turn SEC has also filed another request in response to Ripple's request, and here is that tweet from attorney James K. Phelan. The SEC has filed its response in partial opposition to the Ripple's defendant's motion to seal certain documents filed in connection with the parties' cross motions for summary judgment. And to give the context here behind the SEC's this filing, so Ripple also filed a request to the court to redact or seal many documents from their side, especially involving Ripple's historical financial information or Garlinghouse bank accounts information or some key parties associated with Ripple's their bank account information, etc. And here now SEC is requesting the court to make those documents public as well. So let's see their SEC's logic here and what they are saying. And this is the document that SEC has filed. And here the defendants means the Ripple. So the SEC respectfully submits this partial opposition to defendants' motion to seal certain portion of the parties' filings in connection with motions for summary judgment. Defendants seek complete sealing of or reductions to over 900 documents. Okay, so these are the 900 documents that Ripple wants to be sealed. And okay, let's move on. The SEC does not generally object to defendants' request to redact full financial statements or other summary reports and forecasts. However, the SEC objects to defendants' overly broad approach to the redaction of financial information, which seems to entail redacting every mention of a fact or figure that could potentially be deemed financial. As explained below, because of this information goes to the heart of the summary judgment motions, and because defendants have not made a specific showing of competitive or other harm from disclosure of this information, defendants' overly broad sealing request should be denied. The SEC does not oppose the sealing of Ripple's most current financial statements from 2020, but opposes the sealing of earlier ones. Indeed, the financial statements that defendants refer to as recent date back to 2013, and the most recent for 2020 is already years old. The SEC thus opposes defendant's motion to seal 5 earlier financial statements as stale records that cannot support the necessary finding of harm and therefore cannot overcome the public's strong interest in disclosure. Defendants also, here again, defendants means Ripple. Defendants also seek to seal in their entirety all of Ripple's bank statement. While the SEC does not believe the document should be sealed in their entirety, partial sealing, including redaction of bank account numbers, should be limited to the requirements of Fed.R.CIB P5.2. Anyway, so in the alternative, the SEC would be willing to agree to seal those documents in their entirety on the condition that SEC can rely on information from these documents in its public filings. Another example of defendants' overly broad reduction of information relevant to the SEC's Howey argument is their request to redact the amount of compensation Ripple offered to certain trading platforms to list XRP. This information also evidences Howey's common enterprise and efforts of others' prongs and is therefore relevant to the summary judgment decision. Defendants also seek to redact the amount of Ripple's XRP sales targeted at investors through programmatic sales as well as its institutional sales. With respect to institutional sales, defendants seek to redact both the identities of Ripple's counterparties and the amount of the sales. While the SEC does not object to reduction of the identity of the counterparty, it does object to reducing the amount of XRP sold. Ripple's XRP sales are relevant to all the Howey prongs, including investment of money, and defendants cannot argue that the amount of these sales, especially when not tied to specific identified counterparties, can have a detrimental effect on Ripple's business. For example, defendants' proposed redactions to PX626 include financial information about Ripple's ODL or on-demand liquidity product. Ripple's supporting declaration broadly states in conclusory fashion that its business would be harmed if information about the cost and expenses of the ODL product were publicly disclosed. But the declaration makes no effort to distinguish between current and dated information about the ODL product, including why older information remains highly sensitive. Moreover, Ripple itself has put its ODL product at the center of this litigation, boasting that the purported success of the product is a use for XRP that cuts against the SEC's argument that XRP offerings are securities offering. The SEC is of course entitled to present evidence about Ripple's efforts to prop up the ODL product, and information about ODL's cost and expenses are central to the point. Ripple cannot argue that ODL is relevant and at the same time deprive the public of information about that product based on a non-specific claim of potential competitive harm. This is especially true at the summary judgment stage, where the presumption of public access is at its strongest. So yeah, presumption of public access, this particular argument has been used again and again by both parties in this case, I can see. Alright, moving on, the SEC respectfully submits that defendants' attempt to block the public from accessing any of the financial information associated with their business activities is inconsistent with the standard, grossly overboard, and should be denied. Second, the defendants seek to redact the names of trading platforms throughout the summary judgment papers, even though any trading platform that makes XRP available for trading presumably does so publicly. Moreover, defendants have put the identity of these trading platforms at the center of the summary judgment motion, asserting that XRP transactions on platforms their expert determined to be foreign-based did not occur in the United States. Defendants nevertheless now ask the court to order the SEC to redact the names of all these platforms from its summary judgment papers, but such redactions would impede the public's understanding of the SEC's analysis, demonstrating that the XRP transaction at issue are indeed US-based. And the identity of certain of these platforms is also relevant to the SEC's Howey arguments because it evidences defendants' efforts to list XRP on US-based platforms in an effort to increase its price and liquidity. Defendants similarly argue that XRP's availability on various trading platforms support their fair notice defense. The SEC therefore objects to defendants' request to indiscriminately seal all mentions of third-party trading platforms. Yeah, so looks like SEC is putting up a strong fight against Ripple as well. Alright, lastly, this is pretty much the last part of this document. Here, the SEC likewise objects to the sealing of Garlinghouse compensation information. In addition to its relevance to the Howey analysis, this information evidences Garlinghouse's motive and substantial assistance to Ripple's scheme and is therefore relevant to court summary judgment decision and to any future disgorgement award. As a named party actively litigating against the SEC, Garlinghouse's personal privacy interest cannot overcome the presumption of public access at summary judgment. Alright, so that was the motions from SEC's side. Now let's have a quick look at the most important dates as they're all coming very close. So January 9th was the date when parties filed oppositions to omnibus motions to seal that were filed on December 22, 2022. Now next date is January 13, where the parties must file the Daubert motions and accompanying exhibits on the public docket with redactions consistent with the court's December 19th ruling. And finally, January 8, all parties and non-parties must file oppositions, if any, to the non-party motions to seal that were due on January 4. And James K. Phelan also tweeted this about another event on this case. A non-party called investment banker declarant who submitted a declaration to facilitate the SEC's investigation of Ripple filed a motion to redact his declaration in support of SEC's motion for summary judgment. Yeah, so this declarant, investment banker declarant who is non-party in this case, has filed a motion asking to redact previous declaration to be removed. And in case SEC wins, then most US marketplaces could not allow users to buy or sell crypto securities without registering with SEC or getting an exemption first. So this case will be an absolute precedent for all future events to come. That pretty much wraps up this video. If you liked it, do smash the like button and also don't forget to subscribe. See you in the next one.